Brad Williams, Labor Compliance Group newsletter. Civil wage penalty assessment. I'm not an attorney. I'm not giving legal advice. This is a decision based on a prime contractor, M.V.C. Enterprises, civil wage penalty assessment. It appears to be a $40,000 fine. Let me delve into this. Let's turn over a few rocks, see what's going on here. Why is this group assessed a $40,000 penalty? 2022 was the notice of a hearing. Here's this individual worked on a high school. We have a couple people present here. We have a hearing officer. We have a Lance Grosella working for DLSE, Jessica Sabenstein, and this labor deputy commissioner testified in support of the assessment. Here we have a pre-hearing conference 2021. The pre-hearing conference, they talked about the work subject to the assessment was performed on a public work. The assessment was served timely, the request for review was timely, and the enforcement file was requested and produced in a timely fashion. Those are all factors that can be point of argument. The sole issue for discussion is whether M.V.C. is liable for Section 1776 penalties, and that is for failure to provide certified payroll record on a timely basis. Failure to appear. M.V.C. filed its request in March 25th, 2021. Michael McCoy with Public Works Compliance Advisors appeared on behalf of M.V.C. at a pre-hearing conference on July 26th and on August 23rd, 21. At a pre-hearing conference held on December 6th, the parties agreed to set the matter for a hearing on the merits April 22nd. February 8th, McCoy advised the hearing officer that he and Public Works Compliance Advisors terminated the representation of M.V.C. That's not a good sign. That means M.V.C. not going to show up. So on April 26th, 22, the day of the hearing, there were no appearance by M.V.C. What does that state right off the bat? You don't show up for the hearing, it's presumed that you are guilty. In other words, you didn't provide any documentation up to the April 22nd. You haven't provided any information. So in the end, the case needs to be argued, and this is on the part of DIR, the deputy director, testified on May 22nd. The DLSE received a complaint by Cement Masons Labor Management Cooperation Committee. Again, here's another one of these self-appointed federal management committees, and their complaint alleged that M.V.C. violated apprenticeship standards by failing to employ apprentices. Okay, so then an investigation starts. The document served on both the awarding body M.V.C. asked for, one, it was a notice of investigation. It's a boilerplate document. Request for information from the awarding body. Request for payroll records. Statement of employer payments. Public Works Payroll Reporting Form A131. You don't know what that is. This is A131. It's a standard request. If you don't have it, well, sign up for my labor compliance training online. I'm going to walk you through what all that means. The documents were served by first-class mail and by certified mail with the return receipt. This is all important information. This is all the legal side. As soon as you sign that Public Works construction contract, you are legally required to follow all these very stringent rules and requirements. M.V.C. received the DLSE document, including the request for payroll records, on November 23rd, 2020. The U.S. Post Office provided DLSE with the signed return receipt. Oops. This is interesting because I'm going to have another civil wage penalty assessment where DLSE fined an individual $70,000. And in the end, there was no proof of receipt. And I'll tell you the end result in another newsletter. This letter constitutes a written statutory request from the Division of Labor Standards for Public Works payroll information. If you fail to provide this information, you're going to be subject to serious penalties. Here are the requirements. Within 10 working days from the date of receipt of the request, please submit certified payroll information as described on Form A131. For all workers who were employed by M.V.C. Enterprises on the above identified public works project during the period from the beginning of the project to the end of the project, the information requested must be timely submitted. That's critical, timely submitted. Remember at the very beginning I said timely submitted to the address found in the upper left corner of the requested. You sign that contract. This is part of the requirement. Failure to provide this certified payroll information to the division within 10 working days from the date of receipt will be subject to $100 a day penalty for each worker until strict compliance is effectuated in accordance with the Labor Code 1776H. Well, the guy doesn't show up, or guy or gal doesn't show up. No records were ever provided to DIR. So now it's a matter of how significant is this penalty. On December 7th, in response to the request for information directed to the awarding body, the district provided contract information. The acceptance of work and notice of completion is recorded December 15th, 2020. Again, a critical date because the clock is ticking. So the district accepted the project on October 19th. Since the last payroll record the district provided was for May 19, 2020, the project was not accepted as complete until October 19, 2020. On January 6th, DLSE served M.V.C. notice of impending debarment, et cetera, They just go in and state that provide us the information or we're going to threaten you with debarment. On January 29th, DLSE issued the assessment for penalties in an amount of $40,000. There were 24 workers on the job. Calculate the penalty amount by multiplying $100 per day for 24 workers, which amounted to a daily penalty of $2,400 a day. You then multiplied the daily penalty rate by 17 calendar days to obtain 40 grand. Really? So for 17 days, how large was the contract? 24 workers. Then in February of 2021, M.V.C. payroll administrator emailed the deputy director stating she did not understand why the assessment was issued. Well, I guess there's a problem there. If you're hiring folks that don't understand the public works, that's the first problem. The deputy director explained that M.V.C. failed to provide certified payrolls per section 1776 in response to the request for payroll records. M.V.C. stated she misunderstood M.V.C.'s obligation to provide DLSE with CPRs. Specifically, Hernandez stated it was my misunderstanding that if I entered everything into the LCP tracker in DIR, you would see it. There's the misconception that entering eCPRs is the same thing as a request for information. They're two different requests. Then it looks as though on February 4th, M.V.C. produced CPRs by email. CPR showed 41 workers were on the project from March 4th through November 24th. Here's one critical issue with these civil wage penalty assessments. They're wrong. Most of the time, they're wrong. It could be dates that are incorrect. The calculations could be incorrect. The final penalty could be incorrect. DIR is attempting to reconcile this information, and you could see they have 41 workers here, and up here they had 28 workers. This penalty was based on 24 workers. They had 17 calendar days. Well, here, this project went from March 4th to November 24th, which is a lot more than 17 days. The end result is, how is this penalty calculated, if at all? Well, seemingly, because M.V.C. didn't show up for the hearing, there's no way to argue this. It appears as though DIR screwed up in their calculations. Clearly, M.V.C. screwed up because, one, they didn't provide timely information to DIR, and two, the numbers are incorrect. Is there a violation of the California prevailing wage law? Yeah. If you fail to show up, one, argue your case, then you automatically lose. So the question now is, if you fail to supply records to DIR, you're in violation. So employers on public works must keep accurate records and make them available for inspection. Contractors must record, among other information, the work classification, straight time and overtime hours worked, and actual per diem wages paid for each employee. The records must be certified upon penalty of perjury and must be available for inspection and furnished upon request. They didn't do that. If you fail to do that, you're going to be subject to a $100 a day penalty. When DLSE determines that a violation of prevailing wage law has occurred, including a failure to produce certified payrolls when requested, it may issue a civil wage penalty assessment. To support this channel, check out my courses. Here we have this great Understanding California DIR labor compliance rules and regulations. This is comprehensive. This is going to cover the A to Z of DIR in terms of legal compliance. Federal Davis-Bacon FAQs. This is I call it my pocketbook. This is just a go-to. If you're familiar with Davis-Bacon, but there's many questions related to Davis-Bacon, here's your source. San Francisco local hire. If you're doing work in San Francisco, you need to review this. Navigating DIR websites, more there than you think. There really is more there than you think. This is a complement to the compliance course. It is an absolute necessity. California prevailing wages FAQ, similar to this Davis-Bacon. If you're familiar with California prevailing wages, there's a lot of questions that you may have answers to, but then there's a lot that you might not. This is I call it just the handbook of FAQs related to DIR. Federal Davis-Bacon Contractor's Guide. You're doing Davis-Bacon related work and you're shooting from the hip, don't. Take a look at this course. It's going to answer a lot of those questions that DIR is going to mandate. It's going to require upon you. And consulting. I still do consulting. If you want to do one-on-one training, still do Davis-Bacon and DIR related training. If you need a large project monitored, 5 million above, I'll take a look. And if you have questions that you can't find answers to, give me a call, email me. If this newsletter has been helpful, subscribe, give me a thumbs up, hit that like button, check out the links below. It did. So now it's a matter of the penalty assessment. DLSE presented evidence providing factual support, prima facie is just factual support, for violation of California Labor Code 1776 in the sum of 40 grand. DLSE showed that it served M.V.C. with the request CPR twice as well as the assessment. In addition, DLSE demonstrated that M.V.C. received the request. They got verification of the request for information. DLSE, having met its burden, M.V.C. had the burden of proving the basis for the assessment was incorrect. M.V.C. failed to do so. It did not appear at the hearing to explain how the penalty assessed was incorrect. Moreover, the evidence of record indicates that M.V.C. would not be able to meet its burden. M.V.C. received the request for payroll records twice. You're going to see it. They rehash over and over and over again. But now the question is, it should be noted that DLSE only assessed Section 1717 penalties for 17 days after January 11. It could have assessed penalties from December 3rd, 10 days following M.V.C.'s receipt of the November 20 request for payroll records. In addition, DLSE could have amended the assessment upward based on when strict compliance with Section 1776 was achieved on February 4th. Moreover, the CPRs provided on February 4th showed 41 workers on the site instead of the previous believed 24. So, in short, there's a 69,007 penalty. As I stated, if you get a civil wage penalty assessment, you need to do your own reconciliation and argue the facts. Here's the bottom line. The project was public work. There was a civil wage penalty assessment. Here are the findings in the order. The project was public work. The civil wage penalty assessment was served. The effective contractor, M.V.C. Enterprise, a California corporation, filed a timely request. DLSE made available its enforcement file timely. On November 20th, DLSE served M.V.C. Enterprise with a request for certified payroll. M.V.C. did not provide that information. Subsequently, DLSE assessed the penalty against M.V.C. $100 a day, 24 workers, 17 days, $40,000. The final ruling, $40,800 for failing to provide certified payroll information. This is serious stuff here. Anytime you sign a public works contract, you're going to be subject to the minutia, crossing the T's and dotting the I's. I also provide consultation. If you have a civil wage penalty assessment, I can walk you through what you need to do in order to address these situations. Again, I'm not a lawyer. I don't give legal advice, but I can advise you as to what steps you can take to possibly remedy some of this stuff. And again, if you take a look at my courses, I'm going to answer 99% of these assessments, these civil wage penalty assessments, so you can avoid the problems. Brad Williams, Labor Compliance Group. Thanks for watching.